Okay, good evening, class. Just want to make sure that we are on and recording, which looks like we are. Good evening. So tonight we're going to learn about freehold estates. And this is chapter 2 for those of you who have the book. So with freehold estates now, we're going to be learning a few different things as segments go on. But the distinction I want you to make here is the difference between a right to use real estate and title. They're two very separate things. We learned from chapter 1, when you buy a piece of real estate, you do gain a bunch of rights called a bundle of rights. But you can also have a right to use real estate without owning title. And as we'll see in later segments, like a landlord-tenant situation, that's what's going to happen. So let's see. So freehold estates are what we're learning now, and a freehold estate is an indefinite period of time. So folks, this is telling us that we're dealing with title. It's for an indefinite period of time that we have rights to own a piece of real estate. And so a freehold estate is talking about title, as opposed to a non-freehold estate, which we'll learn in a later segment. That's talking about a definite period of time. And usually when you talk about a non-freehold estate, you're talking about a lease situation, a landlord-tenant situation, the right of possession. But very separate from that is a freehold estate, okay? It's for an indefinite period of time. And there are different types of freehold estates that folks can get. So what are those different types of freehold estates? Well, the first one is the best. We're working down the food chain here now. And this is called a fee simple, sometimes called a fee simple absolute. This is the best type of title that a person can hold in a piece of real estate. Once again, the way you get title to a piece of real estate is, first of all, in writing. Second of all, it's called a deed, right? A deed. So a freehold estate, the best one is a fee simple, sometimes called a fee simple absolute. It's the highest form, and it's only limited by the rights of others and the rights of government, which we learned about in chapter 1. So that's the best. It's an indefinite period of time. There's no limitations on title, in other words, okay? Now, as we work our way down the food chain, we're going to see some limitations on title. So let's suppose I say to you, Dave, transferring all of his right, title, and interest in his real estate to you. So long as you own the property or hold the property and use it as a farm. If you do not use the property as a farm, then I'm to receive title once again. So my restriction on you is I'm granting you all of my right, title, and interest, but I have a restriction here. It's called a fee simple determinable. And why that is, it's the way I worded it. All right. I'm putting the result of your violation. I'm putting a condition on the property, and I'm saying what's going to happen. The result, if you violate my condition. I say to you, Dave, grants you all of the right, title, and interest in my property so long as you own or use the property as a farm. And if you do not use it as a farm, title is to come back to me. So you get the property and you say, Dave's a nice guy. Thank you very much, Dave, but he's a little crazy. I'm not going to use this property as a farm. I'm going to use it as a bar. And so you go ahead and knock that farm down and you build a bar. Now, what you did is violated my term, my condition on your property, and I say the result right on your deed, although you don't usually see these types of conditions on a deed. It's usually in a will or a trust setting. So you violated my term, and what I said, once you violated my term, title is to revert back to me. Now, a reverter means that the title shifts from one party to another, and usually it's the grantor that receives title back. Okay, so usually it's the person who gave title. The OR word is the grantor, right? You would be the grantee in this scenario. I would get title back. And so it would revert back to me automatically. So a fee simple determinable is a condition attached, which if violates, reverts automatically to the reverting language is stated in the condition. So my condition that I placed on your deed was stated there, and I also stated the result if you violated my condition, right? As opposed to a fee simple with a condition subsequent. Now, a fee simple with a condition subsequent, I'm going to give you another scenario. Dave grants to you all of my right, title, and interest in the property so long as you use the property as a farm. Now, that is the condition I placed on your title, so long as you use it as a farm. But the difference here is I did not state the result if you violate the condition. So, same scenario. You get title, you say, Dave's a great guy, thank you for title, Dave. But he's a little crazy, which you're not far from the truth there with that one. He's a little crazy, so I'm not going to use this farm as a farm anymore. I'm going to build my bar, and you go ahead and you build the bar. Now, I didn't state the result on the deed to the violation of the condition. So I have the option at that point as the grantor to step in, probably take a court action and take title away from you. But if I never take that option, if I never take that action against you, you'll still hold title and you can use the property as a bar. That's the difference between a fee simple determinable. The result is determined by me, is the way you can remember this, as opposed to a fee simple on a condition subsequent. Okay? We'll talk about this more as we go. If you have questions, just bring it up as the class goes on. Now, the next type of freehold estate in our chain of title is the life estate. And so what typically happens with the life estate is a person will hold title for their lifetime, then they die. And by operational law, right, no probate judge necessary, it'll then go to what we call a remainderment, or if we want to be politically correct, a remainder person. So in this instance, I would say Dave grants all of his right, title, and interest to you for your lifetime. And upon your death, it'll go to your children. So what happens is you get title, but it's only for your lifetime. So in this instance, you're the life tenant, right? Because I said you're the life tenant in the deed. And then your children would be the remainder people, okay? Or the remainderment, as we say. Now, where I usually see this common, what's common to me, I do a lot of elder law, and I'll have mom come in. She wants to transfer her property to her children, right? Or she wants her children to get her real estate down the line. And so she'll form a deed, and she'll say, I hereby grant all my right, title, and interest to my children, and I reserve a life estate in myself. So what happens is mom and the children join on the deed. Mom has all of the present interest in the property. She pays the bills, pays the insurance, maintains the property. Upon her death, her children then get title, but they don't have it until the future. So it's a future interest, as we say, for the children. They're the remainderman. Mom is the life tenant. That's the typical instance that I see it. Okay, the next type of a freehold estate down the chain of our food chain here is the homestead. And a homestead is basically, it is a freehold estate, but it's more or less a protection on a freehold estate. That's the way I view it anyway. It's created by Massachusetts law, and basically what it does is it's geared to protect a person in their place where they live, their primary residence. And it's geared to protect the equity that that person has. So if you have a mortgage on your property, you make $1 toward the principal, you have $1 of equity. Well, in Massachusetts now, when you buy a house and you live there, you get an automatic $125,000 of protection in the equity from unsecured creditors. So if there are credit card companies out there trying to sue you to pay them, they can't force you to sell your house to pay them off. Now, when you file a declaration of homestead at the Registry of Deeds, it's a one-page document. That protection bumps up to $500,000 protection, the first $500,000 of equity that the person has in their primary residence. Okay, so that's a homestead. Okay, so moving right along, now that we talked about the types of freehold estates, we're going to talk about what happens when more than one person holds title to a piece of real estate. How can they hold real estate? And I do have some short videos that I did for Instagram, which I put up on the site, but we're going to go through this anyway. So real property may be held by one individual or many individuals. So what happens when you have more than one person? Well, the first type of a concurrent estate is a tenancy by the entirety. Now, for a tenancy by the entirety to exist, the parties have to be married. So I typically will say, husband and wife tenants by the entirety on the deed, or married couple tenants by the entirety on the deed. That's typically the way we say it now in Massachusetts. And what that basically means is when you have a married couple, they're considered one in Massachusetts. And so when they're joined together on the deed as a married couple, tenants by the entirety, there's a right of survivorship. That means that if one of the parties passes away, technically they first of all both have 50% interest in the property. But when one of the spouses passes away, the other one receives 100% interest. Okay, and so there's a right of survivorship. The 50% transfers to the surviving spouse automatically by operation of law, no judge necessary. So that's one thing about second thing about a tenancy by the entirety. First of all, they have to be married. Second of all, there's a right of survivorship. If one dies, the other one receives title. Now, third thing about tenancy by the entirety, it's not easily broken. Remember what I said in the beginning. Massachusetts considers a married couple to be one. So that being the case, they both have to join on a deed to convey title. One cannot do it alone. If one person joins one person of a married couple tries to sell off their 50% interest in the tenancy by the entirety, it will not be effective. You need both parties to sign. So, in essence, what I say in the outline, which is not in the book, the only way that you can sever a tenancy by the entirety is by death, divorce, or agreement. Okay, we talked about death, right? That's a right of survivorship. Divorce severs the tenancy by the entirety. And what happens with that is you go to the bottom of the food chain here that we're going to talk about. The parties become tenants in common with no right of survivorship. Once they're divorced, they separate. Okay, it breaks. An agreement. Agreement's the other way that you can break a tenancy by the entirety. You need both parties to join on the deed. Okay, so that's a tenancy by the entirety. So what's a joint tenancy? Well, that's the next one on our food chain. And so more than one person holds title, and they can be brother and sister, they can be friends, they can be business partners, they can be, we'll talk about that in a second too. That's a different type of a tenancy. They don't have to be married, in other words. They can be married, but they don't have to be. And so what happens with a tenancy, a joint tenancy in this instance, you have two parties, one party dies, the other party receives the 50% interest, so they hold 100% interest in the real estate. So there's a right of survivorship with a joint tenancy. So brother and sister can hold title, right? Brother dies, sister gets 100% ownership without seeing a judge. Now, what else with the tenancy by the, with a joint tenancy, that's what we're talking about. A joint tenancy, one party can sell their 50% interest off. I don't know why they would want to, but they can do that. When the 50% interest is sold to another party, the joint tenancy is severed, and brother now will become a tenant in common with the new party that sister sold her 50% to. So it can be broken easily. In other words, one party can sign off on their 50%, and it creates a tenancy in common. They will test you on that, so make sure you understand. When you break a tenancy by the entirety or a joint tenancy, it becomes a tenancy in common. And what a tenancy in common basically means, and that's the next one down the line, is both parties hold 50% interest in the property. One party dies, it goes down the bloodline. There is no right of survivorship in a tenancy in common. Just hold title together 50-50. They can both sell off their 50% interest to whomever they want at any time. And there's no right of survivorship at any time with a tenancy in common. So that's kind of the lower end of the totem pole. Now, that's a concurrent tenancy. Now, there's a new type of tenancy, which I really haven't seen much of in Massachusetts, but it's called a tenancy and partnership. And with a tenancy and partnership, it's kind of a hybrid. It's almost like the two business partners are married in this one. So the thing you want to take out of that section of your book, which is page is that? 2-4. What you want to take out of that section in the book, it's both parties need to sign off on the deed like they were married, right? They both need to sign off on the deed to convey title. If one party dies, the other part, there's a right of survivorship. The other party holds 100% interest. And if for some reason one party dies, they have to use the property for business purposes. But make sure you read that section and understand it. And of course, you can raise questions about it at any time. I added a little section here for corporate entities because they do talk about it in the book, but they really don't explain what they are. So when you have a sole proprietorship, that means that I have a business. Let's say I have a coffee shop. I never incorporated with the state. When you have a corporation, you have to go to the Secretary of State's office in Massachusetts and file an articles of organization or an article of operation. Okay, it's a formal paper that you file with Secretary of State. You don't do that when you're a sole proprietorship. It's just kind of like me, and I use my own social security number to run my business. So it's really an unrecognized entity in Massachusetts, but you can still file it with the IRS, as opposed to a partnership. Now, a partnership means two folks, two people, two or more people involved in a business, And once again, that's not a formal entity in Massachusetts. You can't file an articles of organization at the Secretary of State's office for a partnership. What you can file for is a corporation, as we all know. You go to the Secretary of State's office, you want to form a business, you're forming a new entity, okay? And that entity has a corporate veil, as we say. I put it here, okay? I think I spelled veil wrong. It's not Vail, Colorado. But in any event, it has a corporate protection in it. And what that means is that the officers of a corporation cannot personally be held liable if the corporation is sued because of a contract situation or a breach of contract or some type of negligence. Now, the officers can be held accountable if there's a criminal situation, like we saw with Enron, right? Those officers all committed criminal acts, and they were held individually responsible for their criminal acts. But for the most part, there's a corporate protection. Someone sues, they're suing the company and not the individual, okay? Same type of an idea with a limited liability company or an LLC. This is kind of a hybrid between a partnership and a corporation. You have some flexibility as to how you file your taxes at the end of the year with an LLC. That's kind of the reason why people do this. And so you file your papers with the Secretary of State's office. They recognize the entity, and there's a corporate protection associated with an LLC as well. Okay. And then once again, the book talks about non-freehold estates, which we talked about in the beginning. Now, moving right along now, the book is kind of shifting from title to the types of rights people have. Remember what I said at the beginning, there's a difference between title and rights. So the first thing that they talk about here is the right to use someone else's land. It's called an easement, and for that, I have opened the paintbrush. Now, the first type of an easement that we're going to talk about here is an appurtenant easement. And with an appurtenant easement, you need, let's see if I get this out good. You need two parcels of land, either side by side or one behind the other, okay? But you need two parcels of land when you're talking about an appurtenant easement. And one parcel will serve the other. So we'll call this parcel D and this parcel S. Sorry about this, but it's a little hard to draw at this sometimes. So what happens? Well, this is going to be Happy Street over here, okay? And so D is our dominant estate, and he's going to have an easement over S's land, okay, to get to Happy Street. Now, S owns the property, but D has the right to use S's property. So S is the servient estate. D is the dominant estate. The servient estate, like any other servant, serves the dominant estate, okay? And so S still owns the property, but D has a right to use a strip of S's property. So the idea behind this is D has a responsibility only to use his or her easement as it's written in the deed or whatever the other document was used to form the easement. And so D can only go back and forth over the property to get to Happy Street. D can't put a fence here. D can't park his cars here. D can't make a garden right here, right? D can only go back and forth over S's property. Now, likewise, S cannot block D's access to Happy Street. S has got to allow D to go back and forth. Now, what happens as far as the maintenance of this easement? Usually it's D's responsibility to maintain it because D's got to get to the street, right? But parties can talk. Hopefully they get along. The parties can talk as to how the maintenance is going to be shared. But S has a responsibility not to block D's access to the road. So S can't put a garden there or a shed there or anything like that, all right? So that's an appurtenant easement. That's the first type of easement we're going to talk about. There are two basic categories of easement that we'll discuss. The first is appurtenant easement. You need at least two parcels of land. One's going to serve the other. Okay, good so far? Now, what's the next type of an easement? The next type of an easement is an easement in gross. And so with an easement in gross, you don't necessarily need two parcels of land. And the way I usually explain it to classes is think about something gross, like a sewer pipe. That might be servicing this parcel of land, right? The utility company usually holds these types of land. So let's say B is the owner, okay? The utility company is going to have the ability to service this easement that they have. And every property has this type of an easement. If you have wires coming from your house, well, That might not be a thing in the future, but right now it still is. You have wires coming into your house. Well, the utility company has the ability to service those wires. If you put anything in the way of those wires, the utility company has a right to knock that thing down to get to the wires. Same with an easement, subsurface easement here for a sewer pipe. If you put a shed on top of this sewer pipe and the utility company needs to get at it, they can knock the shed down. Same with the driveway, right? So you have to be careful to look at your easements before you install those types of things on a property. But the idea is this is an easement in gross. Okay, so the first one we talked about is an appurtenant easement. Think of the word tenant right in the word, right? You need 2 parcels of land. The next type of an easement is an easement in gross. And think of your sewer pipe. You don't need another neighbor there. It's usually a utility company. And with a commercial easement in gross, as we say, those are easily transferable. They'll ask you this question on the exam because it has to be, right? If it's a utility company that has the right to service an easement, then they have to be able to transfer it when they merge, they sell the company, right, to the new company. So it's got to be transferable. Now, you can also have an easement in an individual. And so let's say B is on the water line here, right? And the neighbor Joe has the ability to walk over the property to get to the beach. Well, Joe, the neighbor, might have an easement in gross it's called a personal easement in gross. And with those types of easements, you cannot transfer those easements. The only person who has the right to use this easement over B's property is Joe. And Joe cannot sell that property, that easement right, to anybody else. He can't even transfer it to his family. It's only in Joe. When Joe dies, that easement dies. So that's the difference between a personal easement in gross and a commercial easement in gross. But those are the 2 big categories of easement that you need to understand. Okay? That's a right. So that's our first segment here under rights. And I talk about our categories of easements down here, appurtenant easement and easement in gross. Just make sure you understand the difference between the 2 of them. Oh, and there's 2 other categories that they talk about in the book here that I almost failed to mention. One is an easement by necessity, okay? With an easement by necessity, you need, once again, our 2 parcels of land. And let's say we got this parcel. Sorry about the rough draft here, but I'm using paintbrush, so it's not as always as good. We have rock on this side. We might have trees on this side. We might have a river in the back here. So B is going to be landlocked. And B needs to get over A's property in order to get to Happy Street. Well, B can ask A for an easement, but if A says no way, B might have to go to the land court and try to obtain an easement by necessity. The easement by necessity is saying that B's only way to use his property because it's landlocked is to get over A's property. And that's an easement by necessity, okay? And then the other category, the other subtopic they talked about in the chapter was an easement by prescription. And with an easement by prescription, you might have the ability, if you have 2 neighbors again, right? Let's say they share a driveway right here, okay? And this is B, okay? And let's say A was using B's property to get into the driveway, and then all of a sudden B and A have a fight, right? And B says, you can no longer use my property to get into your driveway, and he fences it off. Well, A can go to the land court, and A can say, well, I've got a prescriptive easement because I've used B's property for 20 years of open, continuous, notorious use. He's got to be able to prove it, but he can pretty much have the court grant him the right to use B's property by a prescriptive easement if he qualifies with all of the elements. He's used it 20 years, open, continuous, notorious use. That's an easement by prescription. Okay? All right. Moving right along. How do we create an easement? It's usually a writing. You either put it in a deed. You can get it by prescription, open, continuous, notorious use, or you can go to the court and have them grant you one. Or the other thing I've seen is 2 parties just coming to an agreement because they like each other, and they come to an agreement and they record it at the registry of deeds. Okay, what's the next type of a right that a person can have? How about a license? Okay, a license can be verbal, although it's recommended it be in writing. Everything with real estate should really be in writing. And it is revocable by the person who granted it, by the owner of the property. So a license is a right, a granting of a right to use it. Let's take a scenario where we had A and B, right? And I said it was an easement. Let's say there was no easement, right? And let's just say A is a good guy, and he says to B, you can use my property to get to the beach, right? So B has the right to use A's property to get to the beach. Well, at any time, it's a license. Okay? At any time, A can take that right away, and there's nothing that B can do. Okay? That's a license. A grants it, A can take it away. That's a license to use a piece of real estate. Now, dower and curtsy, once again, just read that section in the book. But a dower has the rights of a wife. Curtsy is the rights of a husband. And what happens is sometimes when a husband dies and he doesn't name a wife as having an interest in, let's say, a particular piece of real estate for whatever reason, the wife can claim her dowry rights, which is about usually 1/3 of the estate. So the wife automatically, or the husband automatically, has a 1/3 interest in the property of the spouse that passed away. Okay, dower and curtsy. Now, what's an encroachment? Well, what I usually do in this instance is I talk about a football scenario. So we have A here. An encroachment is just an infringement on another party's right to their real estate, okay? But A and B. Let's say that A has a tree and the limb goes over into B's property. Is that an encroachment? Well, yes, it is. An encroachment is an infringement on another person's rights. If you break the plane, like in football, if you break the plane of the end zone, it's a touchdown. So if you break the plane of B's property in any way, it's a touchdown. It's an encroachment. So the tree in this instance, the limb is an encroachment of B's airspace. Okay. Let's say that A has a drainage pipe and the drainage pipe goes this way. Is that an encroachment on B's property? And drainage pipe is underneath the ground. The answer is yes. That's once again, you broke the plane. It's a touchdown. You broke the plane of B's property. It's a touchdown. It's an encroachment of the subsurface rights of B. Okay, I'm gonna get now an easy one, right? Let's say he puts up a shed right here. All right, a shed. Is that an encroachment? And the answer is yes. Broke the plane, it's a touchdown. It is an encroachment of B's surface rights. So an encroachment is an infringement on someone else's rights. You have to break the plane of that lot line, and once you do that, it's an encroachment. Touchdown, right? Okay. What else? Restrictive covenant. Basically, with a restrictive covenant, that's another restriction that can be placed on a deed by the grantor. Usually in this instance, the grantor is a developer, and the developer can do things like in the Pine Hills. That's always the instance I use. The Pine Hills is a very large development down in Plymouth, and they can only paint their houses a certain color. They can't park any commercial vehicles out in front of the house. They can't have antennas or satellite dishes on the top of the houses. And so those are restrictive covenants that are placed on the deed that can be enforced by the owners association or the developer if the property owner decides that they want to violate those restrictions. It's called a restrictive covenant. Okay, make sure you read that section. Encumbrances and liens, okay? Encumbrances are the big umbrella term. It covers a lot of different things. A lien falls underneath the umbrella. It's being protected from the rain, right? A lien is basically when someone is owed money. They go to court and the judge says, yes, the money is owed. The party that got the court order can go to the registry of deeds and record a lien, which is someone's owed money, right? It's a money situation. Another type of encumbrance would be an easement. An easement is an encumbrance because, once again, it just affects title. If something affects title, it's an encumbrance. Okay. A mortgage is an encumbrance. Let's see. We have easements. We have mortgages. Any types of other rights that someone grants, like a license, that's an encumbrance on a piece of property. All of those things fall under encumbrance, the word encumbrance. Okay. And then the last section of this outline, not necessarily a book, but this outline that we're going to cover tonight, is water rights. And you have two basic situations with water rights. Make sure you read the section. But there's a difference between literal and riparian. With the literal water right, it has to do with a pond or a lake. And usually I make a drawing like this, and I make my houses on the side, right? One, I'm sorry about the crudeness of this, but I'm doing it in paintbrush. It's not always that easy. Two, all right? So you have your owners all along here. And what that section of your book is going to say, we're on section, bring my book over here. Yeah, 6. And so we're literal rights. If it is less than 10 acres, it's owned and controlled by the abutters. Oops. So less than 10 acres. Everybody owns a piece of the pie, as I usually will say, right? That's less than 10 acres. Less than 10. If it's greater than 10 acres, oops. If it's greater than 10 acres, the state owns it, and the abutters only have up to the water line. If it's greater than 20 acres, then the public is allowed access to it if it's greater than 20. Joe Public has the ability to put their boats in and use it as they please. Okay, so that is literal. Now, the exception with literal, usually you're talking about lakes or ponds, but the exception with literal is the ocean also falls into the category of literal, not riparian. So make sure you understand that. Make sure you read that section on oceans and where an owner actually owns, where that law line comes to. It could be the low mean watermark or the high mean watermark. Just make sure you understand the difference between them. If you have questions, ask. That's under literal. Riparian has to do with rivers or streams, okay? And so if you can get a boat down, if it's navigable, right, then the owners only own to the banks of the river or stream. They only own to here. Boy, this is pretty crude. Okay, if you get a boat down, if you can make that out. There's my boat, here's my river, sorry, and here's my houses, and they only own to the banks of the river, I'm sorry. All right, if the boat cannot go down the river, and I'm sure there's some dimensions that the state sets out for this boat, then the owners will own to the middle of the lake or stream, and they can control what happens in that lake or stream. Okay, and that's the difference between those. So, this is Freehold Estates, Chapter 2. I hope it held your interest. I hope you liked my usage, although however crude it was, of paintbrush. And we will be covering more as we go on with more sections. So I thank you for your time, and I'll see you in the next section.